Christina Della Rosa.
North Broward, Judge.
Thank you.
Your Honor, she's actually supposed to be at the Paul Ryan facility, but she's going to be a medical reset.
Okay.
It's a, out of state hold.
Your Honor, I was hoping, well, nothing on this case. If we can call a case at a turn, I have a detective outside.
Sure.
Defendant's name is Kevin Reed. If you tell me what page Reed is on. I believe there's a family for Mr. Reed in the courtroom as well.
Okay. What,
I'm finding that right now. Just an ag assault at the top of the page.
Mr. Reed is here at Maine. What page is Mr. Reed on?
yeah, we're trying to find that right now.
Okay.
Page
Page 11.
11.
Page 11, thank you. Judge, he has private counsel, Mr. Harold Weitzman.
Okay, hold on one second. I'm still looking for it in the. Okay. Mr. Reed, you were charged with one count of aggravated assault with a deadly weapon. I do find probable cause. Ma'am, you're here on his behalf?
Yes, I'm his mother,
Okay.
and I would like to say a few things if I could.
Sure.
The DA, I don't know why they had him arrested. They never heard the real side of the story, which they should have before they decided to put a warrant out for his arrest.
Okay.
Mike is the Sunrise officer. I gave my statement to last night, and I believe he's outside.
Okay.
And Kevin did not do what they're saying.
Okay. All right.
So
All
I'm
right.
hoping,
All
you
right.
know.
Did you have somebody that wanted to address the court?
No, Your Honor.
Okay, I thought that.
No, he's just came here to find out what happens. He's
Oh, okay. All right.
Detective White.
All right. Does Mr. Reed have a prior history?
Yes, Your Honor. First, to advise the court, Mr. Reed was arrested last year for battery and theft. Those charges were dropped. I would want to advise the court. I did check the original probable cause affidavit in that case. It does not appear that there's any, at first glance, connection between the alleged victim in that case and the alleged victim in this case. I would note the allegations in that case were that Mr. Reed, in addition to the alleged battery and theft, threatened the alleged victim with a 10 to 12-inch wooden bat. Also, 2011, possession of cannabis. 2010, felony possession of cannabis. 2008, possession of cannabis. 2007, possession of cannabis. 2007, possession of cocaine. And possession of cannabis. Your Honor, based on the level of violence alleged in this matter, state would be seeking a $10,000 bond in an order of no victim contact. Actually, no victim contact and no contact with, one moment, Your Honor, the daughter of the alleged victim, who is also an alleged witness to this incident. I believe her name is Brittany Wright.
That's his wife, correct?
No,
That's
no, no,
his
no.
girlfriend,
Okay.
And there's actually,
ex-girlfriend. And the
Ma'am,
mother
ma'am.
is the Anne Marie Brown who
Okay, ma'am,
started
ma'am,
all this,
Ma'am, please.
who lied.
and there's already a injunction, order of protection in place.
Okay.
So, you know.
I understand. Okay. All right. I do note that this incident is alleged to have occurred in February of this year.
Yes.
And he was just arrested yesterday.
9 months later.
And having found probable cause, I am going to set bond in the amount of $5,000. And I am going to order no contact with the victim or the victim's daughter.
They have a baby together. So,
Ma'am, please, I gave you an opportunity to speak.
I'm sorry.
There's not going to be any contact with the victim or the victim's daughter. And he will be, if he bonds out on the $5,000, he'll be on pretrial, straight pretrial. Yeah, there's no contact with the.
And Your Honor, just for the record, I did confirm, the daughter's name is Brittany Wright.
Okay.
Wright, Wright. It's on the PC.
Okay, ma'am. Kimberly Gleaves. Good luck to you, sir.
Medical reset, Your Honor.
Maybe.
Samantha Schneider.
No, Your Honor.
Morning, Ms. Schneider. You are charged with 5 counts: possession of alprazolam, violation of probation, driving while license suspended, an expired tag less than 6 months, and no tag lights. I do find probable causes to all 5 of those. However, on count 1, it's a $1,000 bond. On the violation of probation, you are being held no bond, and there's no bond. There's a 0 bond on count 3, which means no money needed on that. The other 2 are infractions, so there's a 0 bond on that. You do have a status conference set for the 21st at 9 a.m. on your violation of probation in front of your division judge. So your total bond is $1,000. However, there's a no bond hold on the violation of probation. Good luck to you.
May I say, may I speak, Your Honor?
You may, but I don't recommend it.
Could you just let
You know, if anything you say is going to be recorded and could potentially be used against you. So, understanding that, go ahead.
Okay, I'm on administrative probation. I don't know if you're aware of that. I have 2 small children, and I have a surgery scheduled for Monday morning for like a medical surgery that's medically necessary. This whole situation was, I mean, this is like too much for me to be in jail, you know, even for the next couple days, because my children, they don't have a caregiver. I don't even know where they are right now. And my mom has cancer, so she usually is with them, but she's been going through chemo. I'm supposed to be there with her. Like, the fact that I'm on administrative probation means I don't have someone I check in with. I don't have like drug tests or anything. I don't have any stipulations, but don't get in trouble. You understand?
Right.
So like,
And apparently
I
you
don't
got in trouble.
report. So is there any way I can have a pre-trial release or a bond on the VOP until, just so that, because I can go home and be with my family the next couple days? Like,
As much as, even if I wanted to do that, I don't have the power to do that. I'm not the one who set your no bond hold, and that has to go in front of the division judge.
Actually, Your Honor, to be frank, it's a 94806, so it's a warrantless arrest for VOP. But I would note, just in response to everything Ms. Schneider's been representing, I would note this was arrested, it was made at 4 in the morning. And it just,
yeah,
Ma'am, don't talk about the facts of the case, ma'am, okay?
it just doesn't seem, at first glance, someone with the responsibilities that Ms. Schneider is representing the court that she has would be out at 4 in the morning, driving illegally.
to the corner store, just to the corner
Ma'am,
store.
ma'am, this is a public defender. Please don't talk about the facts. Everything's recorded. They can use all of this against you, okay? Don't say anything.
So,
The court, it's in the court's discretion. We would be asking that it be, she go before a judge, but it is legally speaking within the court's discretion.
right, okay, so since it was administrative probation, it was a warrantless.
No. It was, what happened was the officer made the arrest on the new charges, saw that she was on probation
Right.
under Florida
Okay.
Statute 94806, charged her with violating probation. I can tell you, she was just placed on 2 years probation September 6th of this year. 2015, possession of PVP and hydromorphone, she violated her probation. 2006, 2 counts of delivery of alprazolam, violated her probation.
Ma'am, I'm not going to touch the bond at this point. You know, you're on administrative probation, I appreciate that, but you were just placed
That
on
was dropped and that was expunged and not, like, I don't know how that can be brought up. I'm just saying. And the Xanax are my mother.
Ma'am,
and it's
please,
car with
please,
mine.
ma'am, please, stop talking.
Ma'am, quite frankly, in the probable cause affidavit, you said the Xanax was your friends. So, good luck to you, ma'am.
No, I didn't say they were my friends. I told her it was my mom. She was lying.
Good luck to you, ma'am.
Her right to stay there. No use of personal ID, unlawful use of false names, if that, she doesn't have.
Topeka Grant.
Both brought, Your Honor.
Good morning, Ms. Grant. You are charged with 12 counts. Counts 1 through 6 is burglary of an unoccupied conveyance. Counts 7 through 12 are petty theft. I do find probable cause as to the 12 counts. State.
Is that open? Yes, 10-9. Okay, I'm showing she's at, excuse me, Judge, she was arrested October 9th of this year in Boca Raton for loitering and misdemeanor possession of marijuana and drug paraphernalia. I'm being told that is still pending. Go to CCIS. Go to CCIS. Nothing else, Your Honor.
All right, Ms. Grant. Having found probable cause on all 12 counts, I am setting bond on counts 1 through 6 at $1,000 apiece. Count 7, the standard bond is $100. Count 7 through 12 is $100. I'll leave those where they are. So it's going to be a $6,600 bond. Good luck to you, ma'am. Gentleman Kornstein?
Yes.
Both brought, Your Honor.
Good morning, ma'am. You are charged with 1 count of violation of your probation on a felony charge. I do find probable cause on that. You're being held no bond. You do have a status conference set on the 27th of this month at 8:30 in the morning in front of the division judge that you're on probation with. Good luck to you, ma'am.
Okay, thank you.
Artricia Miller?
Main jail.
She's here present, Judge?
Good morning, Ms. Miller. You are charged with 2 counts. The first is violation of probation on a felony. The second is an out-of-county hold. Looks like Dade County. I do find probable causes to both of those. Count 1, your violation, you're being held no bond. Dade County has set a bond on that hold of $40,000. You have a status conference set on the 28th of this month at 8:30 in the morning in front of the division judge that has your probation. Good luck to you, ma'am. Cheyenne Williams?
She's here present, Judge of Maine?
Ms. Williams, you're charged with 1 count of robbery with a firearm. If you find probable cause.
And, Your Honor, because this is a punishable by life offense under Isaza v. State, and also Gallo v. Lamberti out of the 4th DCA 4D07-4171. And Your Honor, I bring this up because it is commonly argued about the standard of proof evident or presumption great that it is above and beyond a reasonable doubt. And I want to note this 4th DCA case from 2008, which I checked in Westlaw Still Good Law, citing Elderbroom v. Knowles. We noted that where the state's evidence is arguably sufficient to convict, but is contradicted in material respects, such that the substantial questions of fact are raised as to guilt or innocence of the defendant, that a trial court may properly find that the proof of guilt is not evident or the presumption of guilt is not great. Noting, Your Honor, that the state's burden in order to foreclose bail as a matter of right is to present some further evidence which, viewed in the light most favorable to the state, would be legally sufficient to sustain a jury verdict of guilty. So, according to the 4th DCA's holding at this point in time, it is actually not above beyond a reasonable doubt. Saying that, Your Honor, relying upon the probable cause affidavit, I believe that there is sufficient evidence for the court at this time for first appearance purposes only to make a finding of proof evident or presumption great.
Ma'am, you're here?
I'm her mother.
Okay. Is there something that you want to say?
Yeah, I'm really not sure what's really going on because my daughter's armed burglary or never even done anything.
All right. It's an armed robbery charge, which stems from a Craigslist ad. And the allegations are that she went to buy an iPhone from somebody in a Wendy's parking lot, and the person that she was with produced a firearm, and they took the phone and fled. There's an allegation that the person apparently got a license plate number, and that's how your daughter was arrested. State, does Miss Williams have priors?
One moment, Your Honor.
Judge, we would just argue, as we always do, that basically proof evident presumption great is the greatest, if not one of the greatest, burdens that would be for the state to overcome. Here, we only have, again, a probable cause affidavit. There's no testimony. There's nothing indicating what actually happened at the scene other than the police officer's narrative. Based on that, I don't believe the court could find a finding of proof evident presumption great, and that we would ask the court not to foreclose the bond. However, if the court's inclined to do that, we would ask the court to use its discretion in setting a bond.
Anything in regards to?
I'm looking, Your Honor. Just show a juvenile prior, misdemeanor prior that she went through diversion program on. But I would also note, Your Honor, and I don't know what's going on with the investigation, but it also is alleged in the probable cause affidavit that she was involved in the burglary of her grandmother's home where her car was stolen and her identity was verified by her own grandmother.
No, absolutely not. Can I just state, absolutely not. That was they tried to charge my son and all that was dropped.
Judge, if I could be heard, because now I think we're going into other issues besides proof evident presumption great, so now I want to go into her type of community.
Right.
She's a single mother. She has 2 kids, Your Honor. She has a 10-month-old and a 2-year-old. She's basically going to Florida Career College. She's studying to be a medical assistant. She, at this time, is almost about to graduate, and she's looking for work. This is her first contact with the criminal justice system as an adult. 1 minor misdemeanor as a juvenile. Judge, I ask you to, if you haven't found proof evident presumption great, I'd ask you to take that into account in determining a reasonable bond, Judge.
Well, in looking at the affidavit to arrest, and it is an affidavit and a sworn testimony, I do find proof evident presumption great. Everything that was testified to within the affidavit basically fit together like a puzzle. And with the further investigation by the detective into the car, it seems like everything seems to fit together and point to Ms. Williams as being the person that had the vehicle. At this time, for the purposes of the bond court, I'm not inclined to exercise discretion in granting a bond. I think that needs to be set for further hearing in front of the division judge, so I'm going to hold her no bond at this point.
And Your Honor, the state would request an order of no victim contact.
Does she go to court, or when does she go in front of it?
If the public defender is representing her, then they will generally get her into court pretty quickly to have a bond review at that point. But honestly, I think that the court is going to want to have more information ultimately before they change the bond. Okay? Good luck, ma'am. Stacy Phillips.
North Broward.
Morning, Ms. Phillips. You were charged with 2 counts, a possession of cocaine and a possession of heroin. I do find probable causes to both of those. Your bond on count one is a $1,000 bond, and count two is a $1,000 bond. Good luck to you, ma'am.
Thank you.
Cassandra Singleton.
No fraud, Your Honor.
Good morning, Ms. Singleton. You were charged with one count of exploitation of the elderly, less than $20,000. I do find probable cause as to that count. State priors.
Check Singleton for anything other than the two Broward priors. Showing DUIs in '09 and '04.
The allegation is that this is her mother that she drove her to the bank to withdraw money. State, do you have a bond recommendation?
Your Honor, state would be requesting a $1,500 bond, but we'd also request an order of no victim contact.
All right, that seems pretty reasonable to me. I'm going to set bond in the amount of $1,500 and order no victim contact. Good luck to you, ma'am.
Thank you.
Carol Miller.
No fraud, Your Honor. She's in a wheelchair.
Okay, no problem. Morning, ma'am. You were charged with grand theft, and then, looks like
Yeah, I guess it would go to order.
8 pretrial warrants, felony pretrial warrants. I do find probable cause. Your bond on count 1 is $1,000. Your bonds on counts 2 through 9 are no bond, so you'll be held no bond until resolution of those cases. Good luck to you, ma'am. Blaze Pratt.
He's here, President Judge. For this case.
I'm sorry?
He's here at Main Judge.
Yeah.
Municipal ordinance case.
Okay, yes. All right, Mr. Pratt, you were charged with a warrant on no lodging on city-owned property. It's a warrant, so I do find probable cause. Morning.
Morning, sir.
Not on this case, Your Honor.
Oh, okay.
Wait a second.
All right. Your bond is $100 on that case. If you want to resolve it, I would resolve it for you today, but it's up to you. You want to resolve the case today, or do you want to post a $100 bond to get out?
I'd like to resolve the case.
Okay. State, does Mr. Pratt have any priors?
Your Honor, I just need his BCCN number.
Oh, okay, you need his BCCN?
Yeah, please.
All right, if you're ready, it's
88
883366.
33. That's easy enough. 883366. What's his name? All right, you let the judge know. Just make sure. Oh, is it juvenile?
He had juvenile prior from 2015, Your Honor.
Okay, Mr. Pratt, if you want to resolve the case today, I would withhold adjudication, meaning not a conviction on your record, and give you credit for time you've already served.
Okay.
All right, so raise your right hand, sir. You swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Can you state your full name, please?
Blaze Jordan Pratt.
Okay, you can put your hand down, Mr. Pratt. Mr. Pratt, I indicated to you that if you wanted to resolve your case today, that in light of the fact that you really don't have any prior record, I would withhold adjudication, meaning that it would not be a conviction on your record, and I would give you, I would take judicial notice of the credit you've already served, the credit for the time you've already served. Is that something you want to do?
Yes.
Okay, sir. How do you wish to plead? Guilty or no contest?
No contest.
All right, I'll accept your no contest plea. I'll sentence you to a withheld adjudication, taking judicial notice of the credit you've already served. Good luck to you, sir.
Thank you.
Sean Morgan.
Mr. Morgan is here, President Judge at Maine. And speaking of Mr. Morgan, Judge, he wishes that, Your Honor, if you would consider resolving his case. My understanding is He was in Indiana. He was searching for a job, and in his job process or interview, they informed him there was an outstanding warrant. He purchased the ticket on Greyhound, drove all the way straight here, and self-surrendered himself. Judge, I'd ask you to consider resolving this case today.
Okay. Give me one second, I thought you were.
No problem, Judge.
State prior history?
Your Honor, prior, he had a 2005 possession of cocaine at a date.
Okay. All right. That's it?
1990, I'm just trying to see what it is. Out of Arizona, looks like a DUI.
Okay. All right, under the circumstances and,
1989 case.
yeah. And the fact that he turned himself in. Sir, if you want to resolve the case today, I would offer you a withheld adjudication, waiving court costs and fines, credit for time you served.
Yes, sir.
All right, sir, if you raise your right hand, please. You swear affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your name, please?
Sean Patrick Morgan.
Mr. Morgan, I indicated to you, based on the charge that's a petty theft from 1989, and the fact that you surrendered yourself and you don't have any significant history, that I would offer you a withheld adjudication with judicial notice of credit time you've already served. Is that something you want to do?
Yes, sir.
Okay. How do you wish to plead? Guilty or no contest?
No contest, Your
All right, sir, I'll accept your no contest plea. I'm going to sentence you to a withheld adjudication, credit for time served. I'm going to waive court costs. Good luck to you, sir.
Thank you.
Judge, good morning. If I can call George Mitchell, he's on page 13 of 15.
17. State 17.
Okay, on this one it said 13, but I apologize. George Mitchell? And for the record, Michael Meyer on his behalf.
Judge, I believe if you're calling a gentleman by the name of Mitchell, we had Mr. Mitchell, he probably just stepped out to use his restroom. I don't know if that's the gentleman you're looking for.
Oh, yeah, I'm looking for George Mitchell.
George Mitchell. Yeah, he's going to be coming in shortly, Judge. He wants to use the restroom.
Okay, I'll put it on brief recall. If you can just let me know when he comes in. He's
Yes, Judge.
got counsel here.
Thank you.
Good morning.
Spanish interpreter, Your Honor.
Is there anybody?
Mr. Mitchell just arrived, Judge.
All right, let me handle that, and then while I'm handling that, if you could find out if anybody needs the services of the Spanish interpreter, that would be great. Good morning, Mr. Mitchell. You are charged with sexual assault by somebody over the age of 18 with a victim under the age of 12. Sir?
Thank you, Judge. Judge Michael Meyer, and again, on Mr. Mitchell's behalf. Your Honor, just a couple things I'd like to point out in the probable cause affidavit. First of all, I think the first and most important thing is that this is an allegation from approximately 24 years ago, when the alleged victim claiming that she was somewhere between the ages of 11 and 17. It is important to note that this is his daughter who's making this allegation. His daughter has been living with him even up until yesterday, and she's 35 years old, with her 3 children, living with Mr. Mitchell up until this point, even as of late as of yesterday. There's nothing in the probable cause affidavit to indicate exactly when this happened. It's a vague allegation as far as the date and time and place of when it happened, whether she might have been 11, 12, or 13. Additionally, when the court looks at the 4 corners of the probable cause affidavit, it seems to indicate that the sexual battery didn't occur until some time later, because there was some groping and some touching, but not a sexual battery that happens until a later period of time. But there's nothing in the probable cause affidavit to indicate when the sexual battery actually occurred. There was allegedly a tape-recorded conversation, and the detective in the probable cause affidavit indicates that Mr. Mitchell never denied it, but it never says that he admitted to it, and I think that that's significant. Judge, he's a 75-year-old individual with absolutely no prior criminal history. He's a United States citizen. He's a lifelong resident of Broward County. He's a homeowner in Broward County. Present in the court is his wife, if I could ask her to stand up, Ms. Mitchell, and also his son, Mr. Mitchell. And they all live in the house with the alleged victim as well. And they can testify to this court that the alleged victim has been living with him even as an adult at the age of 35. Your Honor, he's a retired Broward County worker. He has some serious medical conditions. He takes about 10 different medications. And when we found out about the allegation, I contacted the detective. Mr. Mitchell, knowing the seriousness of the offense, brought himself to the Deerfield substation, surrendered himself, knowing that he would be incarcerated and facing this charge. And we believe that a bond would be appropriate based upon the circumstances of this case, considering the age and the allegations being 24 years ago.
Your Honor, I do believe that there is probable cause, noting the languages between the ages of 11 and 17. I think a plain reading suggests that the conduct was ongoing from those starting at 11 to 17. Also noting as far as the battery, Your Honor, and really I try as best I can not to get into the graphic details, but the allegation of digital penetration would satisfy the statute for battery, Your Honor.
I agree there's probable cause.
Okay, Your Honor, the state is not seeking a finding for the court to make a finding of proof evident or presumption great. We have no objection to a bond being set. In addition to a bond the court deems appropriate, we would of course ask the court to issue a no victim contact order with SM.
Does the state have a bond recommendation, or?
Your Honor, since it is a punishable by life offense, the state would be requesting a $15,000 bond.
Judge, we're amenable to a $15,000 bond, is fine.
Okay, and Mr. Mitchell has no prior history?
No.
Okay, all right. Based on the state's recommendation and the allegations, there is definitely probable cause in this case. The state's not asking me to find proof evident presumption great, and they are amenable to having a $15,000 bond, and so based on the state's recommendation, I will release Mr. Mitchell on a $15,000 bond with no victim contact.
Very well.
Okay.
Thank you, Judge.
Thank you. Good luck to you, sir. Is there anybody there that needs the services of the Spanish interpreter?
Judge, there is one gentleman here that requires the service of Spanish interpreter. His name is Victor Pineda Castaneda. He is on page 18 of your docket. Come on up. Judge, before we proceed, we'd be waiving formal reading of the charge that he was arrested for.
Okay.
Real quick, we set bonded $15,000 and no victim contact. I mean, if the circumstances were different, I was requesting a bond, I would ask for higher, but.
Good morning, Your Honor.
You swear or affirm that you will truly translate from Spanish to English and English to Spanish?
I do. Good morning, Solange Sands.
Good morning.
Good morning.
Oh, okay, would you like? Okay. Good morning, sir. You're Mr. Pineda Castaneda?
Buenos días, señor. ¿Usted es el señor Pineda Castaneda?
Yes.
Yes.
Okay. And you were charged with...
We waived the formal reading of the charge.
Okay, if you can explain to him what he is charged with, that's fine. I do find probable cause.
Hemos renunciado a que se lea el inculpatorio y la señoría decide que hay motivos fundados para el arresto.
State?
Your Honor, just before I make any argument, I'm just going to give
Okay.
Mr. Barbaric a moment to read.
Second.
Your Honor, this is a punishable by life offense under Isaza v. State and Gallo v. Lamberti, both before the Fourth DCA. The state is seeking a finding for first appearance purposes only of proof evident or presumption great, and in order of a no bond hold in order, no victim contact.
Señoría, esta acusación podría llevar a una cadena perpetua bajo un caso que está representándose en este momento. Y entonces en este circuito pedimos que no se le dé una fianza y que se le prohíba la comunicación con la víctima.
I would first note that this is a filed charge. The state has investigated this matter and determined the charge before the court is the appropriate charge to proceed on. I'd be relying on this point. While there are other reports and statements that have been provided, I'll be relying on the probable cause affidavit for this hearing.
Quiero también representar que estos cargos ya se han sido presentados por el Estado, que piensan que hay suficiente alegaciones para presentar los cargos bajo este tipo de delito. En este momento tendría que usar el informe de motivo fundado.
Noting that the allegations made by the alleged victim would satisfy the elements of the offense.
Notamos que las alegaciones de la víctima son satisfactorias para aceptar el delito como presentado.
That her allegations are corroborated by both witnesses.
Que las alegaciones se han corroborado por parte de los dos testigos.
And that the defendant's claims are refuted and inconsistent with the statement made by the victim's brother.
Y lo que ha declarado el acusado no son corroborados o no son iguales a lo que dice el hermano de la víctima.
And Judge, we would, making the same argument that I've made before, that this is one of the highest burdens of proof, that here we have a probable cause. There was nobody to, in reading the probable cause, there's nobody that saw the actual incident. There's nobody that can testify what the dynamic was. Was there some reason for her to perhaps make this up? Is there some reason or something that was going on in the household? So based on that and the fact that this is the highest burden, we would ask the state to tonight find proof evident presumption great and to set a bond. And if the court does find proof evident presumption great, we would ask the court to use its discretion in setting a bond in this case.
Okay, thank you.
Ya que tenemos este tipo de acusación que tiene un resultado tan serio para el acusado, pedimos que entonces no se acepte la presunción en este momento porque no tenemos testigos, no hay nadie que ha visto lo que ha ocurrido y no sabemos si la víctima por alguna razón tenía razón de inventar lo que dice. Quizás tenían algún problema en esa casa. Por eso pedimos que sí se acepte una fianza en este caso.
Okay, thank you. The court notes that in the probable cause affidavit.
La Corte decide que en el documento de motivo fundado
That the alleged victim immediately reported the incident to her mother.
la víctima inmediatamente había reportado el incidente a su mamá
And that her brother also witnessed similar behavior of the defendant.
y el hermano también fue testigo de actividad similar con la víctima.
On the night of the alleged incident.
Y esto fue en la noche del supuesto incidente.
All of the testimony corroborates what the alleged victim stated to her mother.
Todas las declaraciones entonces parecen dar motivo a lo que ha dicho la supuesta víctima a su madre.
And there's no indication that the victim had any other reason to say what she said.
No hay razón por pensar que la víctima tenía alguna otra razón para decir lo que ha dicho.
Based on the evidence, I find that proof is evident and presumption is great.
Y basado entonces en las pruebas, decido que hay motivo fundado.
And I will hold the defendant no bond pending his appearance in the division.
Y entonces decido que se tiene que mantener el acusado sin fianza hasta la próxima audiencia.
Good luck to you, sir. There'll be no victim contact as well.
Buena suerte, señor, y le queda prohibido comunicación con la víctima.
And the alleged victim's initials are KR.
Las iniciales de la supuesta víctima son KR.
Good luck to you, sir.
Buena suerte, señor.
Anybody else need the services of the Spanish interpreter?
Judge, there's no one else here at Maine that requires a Spanish interpreter. I don't know if the other facilities, however, need it.
Okay. Anybody else at Paul Ryan, Conti, or North Broward?
No, sir.
Okay. Does North Broward need the Spanish interpreter? Hearing nothing, I'm assuming they don't. Thank you very much.
Thank you, Your Honor. Have a good day.
Okay. Christopher Grayhart?
He's here, President Judge. This is a county ordinance case. Can I talk, sir?
Hold on for 1 second, sir. Sir, you're charged with a warrant on a county ordinance case. I do find probable cause.
Can I talk?
Sure.
Why this warrant was issued? I was in Palm Beach doing 2 months on a grand theft charge, but they had dropped the charge, so I was wondering, can you go ahead and let me resolve the case today because I was locked up while this warrant was issued, sir, in Palm Beach County?
Looks like it's a.
I'm sorry.
It's a county
Just checking to
ordinance.
see- no, I know.
Oh,
I'm
okay.
just checking to see what. Public consumption.
Okay. Public consumption of alcohol.
I hope. Yeah. Yeah.
All right, yes, sir. Under the circumstances, if you wanted to resolve this case today, I would adjudicate you guilty, give you credit for time served.
All right, thank you, sir.
All right, raise your right hand, sir.
Yes, sir.
You swear affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, sir, can you state your full name?
Christopher Lamar Greyheart, sir.
All right, Mr. Grayhart, I indicated to you that based on all the circumstances around this case, that if you wanted to resolve it today, I would adjudicate you guilty, give you credit for time served. Is that something you want to do?
Yes, sir.
All right, sir, how do you wish to plead, guilty or no contest?
No contest.
All right, I'll accept your no contest plea. I'll adjudicate you guilty, give you credit for time served. Good luck to you, sir.
All right, thank you, sir.
All right, take care.
Mr. Ackerman, come on up.
Joseph Ackerman?
Mr. Ackerman's here, President Judge at Maine. Judge, my understanding is this is allegedly from a Target where the merchandise was recovered. I don't think there's any sort of outstanding restitution issues in saying that. Mr. Ackerman wants to ask the court if you would consider resolving this case today for time served.
My wife would be horrified that somebody's stealing from her favorite store, Target. All right, well, Mr. Ackerman, it is a petty theft. I do find probable cause on your petty theft state.
Your Honor, as far as Broward goes, I'm showing he had a theft in 2011, alprazolam in '01. State would offer time served.
All right. Mr. Ackerman, if you want to resolve the case today, I would take the state's recommendation, offer you an adjudication credit for time served. Is that something you want to do?
Yes, sir.
Okay, can you raise your right hand, please? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, can you state your full name, please?
Joseph Michael Ackerman.
All right, Mr. Ackerman, I indicated to you that I would accept the state's recommendation of an adjudication with credit for time served on this case. Is that something that you want to do?
Yes, sir.
All right, how do you wish to plead, guilty or no contest?
No contest.
Okay, I'll accept your no contest plea. I'll sentence you to an adjudication credit for time served, waiving court costs.
All right, thank you.
Good luck, sir. Patrick Driscoll?
North Broward.
Patrick Driscoll?
He's approaching, Your Honor.
All right, thank you.
Right. Right here, sir. In front of the pulley.
Good morning, sir.
One.
You were charged with 3 municipal ordinance warrants, well, 2 municipal ordinance warrants and a misdemeanor warrant out of the South Satellite Courthouse. Trespass, loitering where sign is posted, and another trespass. I do find probable cause as to all 3 of them.
Your Honor, these are all in Judge Lerner's mental health division.
Okay, so I'm gonna let these go to division. I understand that you're in Judge Lerner's division. It looks like you have a status conference set on these on the 30th at 2 p.m. Good luck to you, sir.
Can I ask you one question?
Certainly.
Could I'll be off and I'll be able to go, but also, could I have a period of, able to go home and with, $30 in my pocket? I need $30.
Okay, well, sir, that might be something that could happen after you see Judge Lerner Rem, but not today, okay?
I want to see Judge Lemsreth.
You're gonna see her on the 30th, okay?
30th of this month?
Yes, sir.
What's the date today, please?
Pardon now?
What's the date again? Today.
Today is the 17th, so it's less than 2 weeks
Okay,
away.
so I gotta stay here, 2 weeks?
Yes, sir. Yes, sir.
But no, I'm just saying I need a lawyer, but it's kind of a hard thing to do is to keep me in jail because of doing that for just trespassing, sir.
Well, sir, the bonds are $250 a piece on there, so
Yeah,
it's a total of
I know that, but
Judge.
I'm just saying.
Judge,
It's kind of hard to
Jay to see
deal
maybe
with
they can get him in sooner.
staying in jail.
Well, what we're gonna do is we're gonna see if we can get you a date earlier than the 30th. The state is here,
Yeah.
and they're gonna see if they can get you a coordinated date
But
earlier.
also, I want to get off the ordeal of not being charged because I'm innocent. I shouldn't be charged, money or whatever. I'm innocent.
Okay, fair enough, sir.
There's no wrongdoing, so I ain't criminally unaccepted.
No, I understand, sir. And what we're gonna do is we'll see if we can get you in sooner, maybe even early next week. Okay? Good luck to you, sir.
All right, so there'll be one more thing. There'll be 2 more court dates.
We started this with one question, but now we're at.
No, okay. Well, you said at first you're gonna speed it up and go to court again, and now you're saying to be next week.
Well, we're gonna try and get you something earlier in front of Judge Lerner Wren. I can't guarantee it, but the state's offered to try, and that's the best I can give you right now. Okay?
All right, thank you.
No problem. Good luck to you, sir. Samuel Christmas.
No problem, Your Honor.
Good morning, sir. You're charged with 1 warrant on a misdemeanor. Looks like a petty theft.
Just checking to see what was going on here. Okay, this was at a Walmart on Broward Boulevard in Fort Lauderdale. $77 and change worth of items.
Wait a second. Hold on.
Sir, don't say anything.
Sorry?
got this, I have a PC from a new arrest for petty theft as well.
This is. Frankly, oh, it's because, Your Honor, the second paragraph, second page.
Okay.
Yeah. But that being said,
Okay.
it's
Yeah, well.
the same, it's the
conduct.
same Walmart that,
Okay, sir, you have a warrant on a misdemeanor. It's a $25 bond. You currently have a status conference set for next Wednesday in the division. And I'm gonna let if you wanna bond out for $25, I'll let you do that, but I'll let the division handle, anything further. So it's set for
That's in
the
there.
11/22 at 9 a.m. Good luck to you, sir. Therese Moultrie?
Mr. Poultry is here, present, Judge Maine.
Good morning, sir. You're charged with driving while license suspended, and then 2 traffic criminal offenses. It looks like another suspended driver's license and a child support driving while license suspended. I do find probable causes to all 3 of those. Your bond on count 1 is $100. Your bond on count 2 is $250. Your bond on count 3 is $100. It's a total of a $450 bond. You do have a status conference on the capiases or the warrants set for the 27th at 10 a.m. In front of the division judge. Good luck to you, sir.
Judge, and speaking of Mr. Moultrie, he's asking or inquiring, Your Honor, if you would consider resolving his cases today.
Well, I'm not inclined to resolve driving while license suspended, especially, with child support allegations. So I'll let him see the division judge or bond out on the $450.
And the alternative, Judge, when was the alleged court date that he missed? Because he did tell me
Sure.
it was during the, I guess, incident when we were having our hurricane.
Well, there's one capias here that I'm looking at that is from October 16th of 2016. October 31st of 2016, and then another one from October 5th of 2017.
It's not right. 2016, you just had a child paying that.
Okay, so one of them was from, I'm assuming that would be in reference to count 3, the 2016 case. He had a failure to appear in October of 2016.
I'm looking at one that says October 31st of 2016,
and October 5th of this year.
and then another one that is October 5th of 2017. Any way you slice it, it's not during the hurricane.
Gotcha.
Good luck to you, sir.
Judge, just to let you know, I got that gentleman. He'll be seeing Judge Lerner right on Monday.
Okay, great. And that was,
Patrick Driscoll.
just to let North Broward know that the state was able to get Mr. Driscoll in to see Judge Lerner Wren on Monday rather than on the 30th, so let him know that, please. Thank you, State.
No problem.
Kenneth Banks?
Mr. Banks is here present, Judge. He's also inquiring if Your Honor would consider resolving his case today.
Mr. Banks, you are charged with 1 count of trespass, failing to leave property. I do find probable cause. State?
Your Honor, I'm showing. Yeah, Mr. Banks has priors out of North Carolina. That being said, it's a trespass at a gas station. It offer time served.
Okay. Mr. Banks, the state is offering you an adjudication credit for time served. If that's something you want to resolve today to that, then I would go along with that. If not, there's a $25 bond.
No, I would like to resolve it today. I'm homeless, I ain't got no money, I'm broke, man.
Okay, sir. All right, then please raise your right hand. You swear affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name, please?
Kenneth Wayne Banks Jr.
Okay, Mr. Banks, you put your hand down. Mr. Banks, I indicated to you that if you wanted to resolve this case today, I would honor the state's offer of an adjudication credit for time served, waiving court costs. Is that something that you want to do?
Yes, sir.
How do you wish to plead, guilty or no contest?
I'll plead guilty.
All right, sir, I'll accept your guilty plea and I'll sentence you to an adjudication credit for time served, and I'll waive court costs. Good luck to you, sir. Stay away from that racetrack.
I can leave it?
Yep. Stay away from that racetrack. Mr. Warshawski, you're gonna be next.
Andrew Warshawski. Hector, you're a mind reader today. All right, Mr. Warshawski.
Just a docket reader.
You were charged with petty theft. I do find probable cause. State any priors?
He's got priors out of the state of Wisconsin, Your Honor. Considering this is his first Broward prior, I would offer him adjudication time served.
All right, Mr. Warshawski, you have the option. You can post a $25 bond, or I would offer you an adjudication credit for time served.
Time served. Let the judge know. Time served.
Okay, sir, raise your right hand, please.
Hello?
You swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yeah.
You sure about that?
Yes, sir.
Okay, thank you. What's your full name, please?
Andrew Jordan Warchowski.
Okay, Mr. Warchowski, indicated to you that if you want to resolve the case today, that I would offer you an adjudication with credit for time you've already served. Is that something that you want to do?
Yes.
How do you wish to plead, guilty or no contest?
Guilty.
All right, I'll accept your guilt.
contest.
Either way, I'll accept, which one? You pick one. No contest?
Guilty.
Okay, guilty.
No contest.
Okay, let's pick one.
No contest.
Okay, I'll accept your no contest plea, sentence you to an adjudication credit for time you've already served, waiving court costs. Good luck to you, sir. Gotta stay away from that bottle of 99 blackberries. Not worth the 2 days in jail.
Big Daddy's liquor. I know.
That was much harder than it had to be. Johnny Ross?
Conti?
Yes, sir. Morning, Mr. Ross. You were charged with a warrant on a felony. Looks like grand theft of a motor vehicle. I do find probable cause. The bond has been set at $1,000 on that charge. Good luck to you, sir.
Your Honor.
Yes, sir.
I've been incarcerated since September 22nd. How's the case warrant for the bond?
Pardon?
I'm sorry, it's a not in custody.
It's a not in custody capias. I'm not exactly sure all the nuts and bolts of that one, but I know there's a not in custody capias, and I know that you're in on other charges, but this one has a $1,000 bond on it. Good luck to you, sir.
Thank you.
Sure. Alex Exantis.
He's here, President Judge of Maine.
Good morning, Mr. Exantis. You are charged with 4 counts, felony warrants, looks like. I do find probable cause on those warrants. It looks like the division judge has set your bond at $1,000 for counts it looks like counts 5, 6, and 7 at $1,000. Count 8 is $100. So it's a total of $3,100. You do have a status conference in front of your division judge, which is Judge Shearer, on Monday at 8:45 in the morning. Good luck to you, sir.
Good luck, sir.
LaSalle Simmons.
Mr. Simmons?
Morning, Mr. Simmons. You are charged with 1 count of petty theft, third or subsequent offense. I do find probable cause. Your bond is set at $750 on that count. Good luck to you, sir. Valeria Jones.
Mr. Jones, come on up, please.
Mr. Jones, you are charged with 5 counts. The first is possession of a weapon or ammunition by a convicted felon. The second is operating without a valid driver's license. The third is speeding. Fourth looks like it's a window tint. And then the fifth is a warrant on a misdemeanor. I do find probable causes to all 5 of those. State, what are Mr. Jones's priors? Indicated that you had a prior out of South Carolina.
Yes. Please, by all means.
Mr. Jones's history out of South Carolina, he has a 2011 possession of drug adjudication. He has a grand theft adjudication also 2011 and a burglary adjudication in 2011. He also might have a possible warrant per NCIC for habitual traffic, which was issued in February of 2017.
Out of South Carolina?
Out of South Carolina. The
Okay.
paperwork indicates that they will not extradite, however.
Okay.
In determining the bond for Mr. Jones, I'd ask you to take this into consideration. He's 25 years old. Basically, he's been in South Florida now for about 6 months. He relocated here from South Carolina. He's going to school. He goes to AIU. He's studying business administration. In 6 months, he advised me he plans on obtaining his BA degree. He lives with his mother in Coral Springs. From what he advised me, his mom is leasing the premises. His mom's monthly rent is about $2,300 per month. She's a retired Army veteran. Judge, right now, from what he's advised me, his uncle, his mother's brother, just recently passed away, and his mom basically spent a lot of her financial resources paying for the funeral costs. I'd ask you to take that into consideration in determining a reasonable bond for Mr. Jones.
State.
Your Honor, hearing everything, state would be requesting a $3,500 bond on one.
More reasonable than I probably would have been.
Well, and that's why I did take into consideration pretty much mostly the last piece of information that Mr. Romero provided.
That's fine. That's fine. I don't know that there's any crimes of violence in this past either, so. All right, I'll take the state's recommendation and place a $3,500 bond on count one. And then counts 2 through 4, the standard bond is a zero bond, and there's no charge on those, and it's a $250 bond on that capias, so it's a total of $3,750 bond on this. He does have a status conference set for the 28th of this month at 9 a.m. on that capias. Good luck to you, sir. Thank you, Mr. Linder. Robert Mueller.
He's here, President Judge O'Main.
Mr. Mueller, you are charged with 2 violations of probation on felony cases. I do find probable cause you are being held no bond on both of those. You do have a status conference set. Looks like Tuesday at 8:30 in front of your division judge. Good luck.
Good luck, sir.
Ricardo Daly.
He's here at Maine.
Mr. Daly, you are charged with 2 counts of violation of probation on felony charges. I do find probable cause you were held no bond on both those charges. Looks like you are set for a status conference on those on 11/27 at 1:30 p.m. in front of your division judge, Judge Merrigan. Good luck to you, sir. Claiborne Chrisman.
He's approaching, Judge.
Mr. Chrisman, you were charged with 1 count of violation of probation on a felony charge. I do find probable cause on that charge. Looks like you were being held no bond on that, and you have a status conference set for 11/21 at 8:45 in the morning in front of Judge Merrigan, who is the division judge.
Your Honor, I believe his mother is present.
Oh, I'm sorry.
He asked me to get a letter. He's in a halfway house, and I guess I don't really know everything that happened, but I know he went to his PO, and I guess it's due to the address. But he asked me to bring a letter down stating where he is living and that he is in a halfway house and in a treatment program.
Okay, so let me just say, for the purposes of this hearing today, I'm just determining whether there's probable cause, and there's a warrant that was signed by Judge Merrigan for his arrest. It does. I will tell you that the warrant does state the condition was that he moved from his last known place of residence without getting consent from the probation officer. That being said, on Tuesday, he's got a status conference in front of Judge Merrigan, and that letter would probably be useful at that status conference in front of Judge Merrigan.
And who do I give this letter to?
Well, is he represented by the public defender's office?
He will probably sign up, yes.
Okay, then I would.
He actually did sign up this morning, Judge, so most likely what will happen is we'll bring in the paperwork and attorney will be assigned probably, tomorrow's the weekend. So I'm assuming probably on Monday.
Right, I mean, it's go ahead, what were you gonna say?
If you're gonna be there, it's probably.
I can't, I live in Palm Beach County, but I can, if I can get the date and the time, I'll be. I can give it to you right now. That's okay.
Yeah, that's fine. That's fine. And just to let you know that is set for Tuesday at 8:45 in front of Judge Merrigan here in this courthouse.
Okay, Tuesday, 8:45.
All right, thank you very much, ma'am. All right, sir, it looks like you've got that court date on the 21st, and your mom has given some paperwork to the public defender, Mr. Barbaric here, and they will get that paperwork into the right hands, okay?
Judge, they'll have that in court on Tuesday?
Yes, sir.
That letter?
Yes, sir.
All right, thank you, sir.
All right,
Thank
take
you.
care. Good luck.
All right.
Thank you, ma'am. Mark McNabb?
Your Honor, it was corrected to reflect, community control.
Okay, thank you. Mr.
Mr.
McNabb,
President.
Mr. McNabb, you are charged with 2 counts of violation of community control on 2 separate felony cases. I do find probable cause you're being held no bond on those charges. You have a status conference set on these charges on the 28th at 8:30 in the morning in front of your division judge, that is Judge Colra. Good luck to you, sir.
Good luck, sir. Down the middle. Mr. Byrd?
Major Byrd.
You're next. He's here, President Judge of Maine.
Mr. Byrd, you are charged with carrying an electric weapon or device, carrying a concealed firearm, and a possession of a firearm on school property. I don't know that I found probable cause on carrying an electric weapon.
And I think that's really carrying a concealed weapon, and that's not a firearm, but I didn't see any other type of weapon mentioned. I have no objection and no PC on count 1.
Yeah, I don't find probable causes to count 1. However, I do find probable causes to carrying concealed firearm and possession of firearm on school property. Any priors?
Your Honor, and Mike, if you want to take a look, he has a substantial juvenile history. If the court, I ask the court, Madam Pretrial has a printout of his priors, and if you want to take, I have it right here if you want to take a look. Your Honor, the other thing I would want to advise the court, and this is not part of his specific offenses in the past, I think I'll preface before I make my bond request. Juvenile judges have found it necessary 6 times in the past to order secure detention for Mr. Byrd. Your Honor, based on his history, the seriousness of these offenses, my concern for the community, I'm going to be asking for a $5,000 bond on count 2, a $15,000 bond on count 3, that Mr. Byrd not return to Flanagan High School campus. Should he post his bond, that he be placed on pretrial release GPS level 1, and that he be ordered, obviously, not to be in possession of any firearms or weapons until further order of the court.
Judge, speaking of Mr. Byrd, he's 18 years old. He's been residing in South Florida his whole life. At this time, he's not working. He's looking for work. He was working for a waste management company. From what he informed me, he just got laid off. He was making about $11 an hour. He lives with his grandmother in Pembroke Pines. His grandmother is retired, so financially, resources are very, very limited. Judge, what he advised me is he's attending Henry D. Perry, which he's trying to obtain his GED. Judge, he's asking or requesting if you would consider pretrial release.
Well, the allegation is that he had a 9mm Glock in his waistband. I'm not sure where that was obtained, but no, I'm not considering pretrial on this. There's very little reason to be on school grounds with a firearm. Accordingly, I'm going to set bond on count 2 at $10,000. Count 3, I'm going to set bond at $10,000. If he bonds on those charges, he will be placed on a GPS monitor.
And, Your Honor, and I understand, and the reason I'm asking for level 1, and I understand Mr. Romero said he's going to school, but based on these allegations, for the safety of the students, even at the school he's attending, I don't believe it's appropriate for him to be on any campus at this point in time.
No, I agree. GPS monitor level 1. No PC.
Your Honor, are you waiving the fees for the electronic monitor?
I will.
Judge, and you're waiving the cost of the GPS?
I am.
Thank you.
And even, and Your Honor, and I'm sorry, and I know it might be a bit redundant with the order level 1, but just to cover my bases, as far as the request of no return to Flanagan High School campus,
That is, I wrote it down, I just.
Oh, okay.
I didn't
Oh, sorry.
say, no return to Flanagan.
and no firearms, and,
Yeah, no possession of firearms or any other weapons.
thank you, Judge.
Judge, I understand the court's ruling, but I know Mr. Byrd did advise me that he does go to school Monday through Friday. Putting him on a level 2 would still allow him to go to school. Would you allow him to, the level of supervision to be downgraded from level 1 to a level 2?
I don't know when he goes to school, but this happened at 9 o'clock in the morning. And he wasn't going to that school. So that'll be denied.
My understanding is school hours, from what he advised me, is 11 a.m. to 5 p.m., Judge.
Still doesn't go to that school.
I'm not inclined to do that. Maybe the division judge would do that, but
Yes,
I'm just not
Judge.
inclined to do that. Gregory Manns?
Mans, come on up, please.
Morning, Mr. Manns. You were charged with 1 count of violation of probation on a felony.
Judge, he declined the service of public defender.
I do find probable cause. You're being held no bond. You have a status conference set on this case on Tuesday at 8:30 in the morning in front of the division judge, which is Judge Siegel. Good luck to you, sir.
Thank you.
Gary McDonald?
Does he have anything outside of Broward, other than?
Mr. McDonald, you're charged with grand theft and fraudulent or insufficient funds. I do find probable cause. Your bond on count 1 is $1,000. Your bond on count 2 is $1,000. Good luck to you, sir.
Judge, in speaking to Mr. McDonald, from what he advised, he's 56 years old, been residing here in South Florida for the past 45 years. He is working, he works for a company called International Furniture Company. He's a carpenter. He's been working with that company about 4 years. He also advised me that he doesn't have any sort of extensive or serious criminal history. He believes his last contact was over like 10 years ago. He's a registered voter here in Broward County. He lives in Hollywood. He's been residing in the same premises for the past year. During this course of this year, he had a rough time. His wife just passed away a couple of months ago. That left, there was many residual effects of that. One of them as far as no one that really out there to be able to post his bond. He's asking, Judge, if you would consider releasing him on pretrial release if the state can verify that, you know, he doesn't have many contacts with the system and they're not serious.
Okay, let me ask the state.
Yeah, I believe that is accurate, but that being said, Your Honor, considering these allegations also include stealing $2,400 in cash, I believe the standard bonds, or at least some bond, is appropriate.
Judge, and I understand as far as where the states is, as far as normally with this type of charge, why a monetary bond would probably be appropriate, but one of the ramifications if his wife passed away is, from what he advised me, his wife was his life, so therefore he has no one to contact. So that's the biggest dilemma as far as no one to post the monetary bond.
Well, they are bondsmen, and they have the numbers of bondsmen in the jail that they can contact. And that's the reason I bring up that it wasn't just items that were taken that might not necessarily have value. There was also allegedly $2,400 cash that was.
Did pretrial interview him? Pretrial did interview him? Okay, I will ROR him to straight pretrial, to standard pretrial.
Okay, could the defendant please state his address for the record?
Say your address for the record.
2035 Van Buren Street, Hollywood, Florida, 33020.
You're gonna straight pretrial?
Judge?
It's an apartment. 9.
It's apartment 9, apartment 9. Yes.
3303020.
Okay, they're gonna verify, and if they can, they'll release you today.
You want to go outside?
Yeah, you go outside.
Thank you very much.
No problem.
Good luck to you, sir. Justin Dupree?
Pre?
Somebody wake Mr. Dupree up?
He was all the way in back, Judge, all the way back there.
Been a long night, Mr. Dupree, I'm sure. Mr. Dupree, you're charged with 6 counts. The first is possession of PVP. Second is possession of cannabis, 20 grams or less. Possession of drug paraphernalia, resisting without violence, violation of probation on a felony, and violation of community control on a felony. I do find probable causes to all 6 of these. On the possession of PVP charge, your bond is $1,000. Counts 2, 3, and 4, it's a 0 charge on that. Counts 5 and 6, the violations, you're going to be held no bond. You do have a status conference set for Tuesday at 8:30 in front of the division judge. And I don't see who the division judge is just yet. Judge McCarthy. So good luck to you, sir.
Thank you, Judge.
Kurt Kuhn.
He's here present, Judge?
I have a probable cause objection.
Okay. Mr. Kuhn, you were charged with 16 counts. Sorry, 17 counts. The 17th being an out-of-county hold.
No.
Count 1 is burglary, unoccupied, or occupied dwelling. Count 2 is grand theft. 3 is burglary, occupied dwelling. 4 is grand theft from a person 65 years or older. Obtaining property under $20,000 by fraud, abuse of the elderly, burglary, occupied structure, unarmed, burglary, unoccupied structure, unarmed. Grand theft, obtaining property under $20,000 by fraud, elderly abuse, burglary of an occupied dwelling, larceny, or grand theft, 65 years, victim 65 years older, obtaining property under $20,000 by fraud, elderly abuse, and a warrant on a misdemeanor, as well as an out-of-county hold. Mr. Barbaric, you had a probable cause argument.
Judge, I had only one incident. I didn't know how they got the 16 counts. But I would argue, I can argue it with regards of the one, and I think that it probably would carry through for the rest because I believe they're all similar crimes. The burglary charges, they didn't break in. They were actually invited in. They went and spoke with the owner. The homeowner allowed them into the house. So I don't know that that would constitute necessarily a burglary.
Under fraudulent pretenses.
Right. With all due respect, gaining entry under fraud does not equal no valid consent. So I respectfully decline your probable cause argument on that, and I do find probable cause as to all 17 count state.
If I could just have one moment, because I know when I'm going to be requesting, I just want to get the numbers right, and I don't have the charges numbers memorized.
Right, that's
Okay,
fine.
good.
Your Honor, obviously, I've got a great concern for the community, particularly the elderly in the community, as it appears that is who is being targeted here. This is not one isolated incident. It does certainly appear that Mr. Kuhn is engaging in a common scheme to commit burglaries against the elderly by fraud. Also noting that he's wanted in Dade County right now, and of particular note is the charges he's wanted out of Dade: credit card fraud, another credit card fraud, grand theft, possession of a stolen driver's license. His criminal history includes out of the state of Ohio, 2000, attempted drug trafficking. In 2000, felony possession of drugs out of the state of New York. Criminal possession of a firearm or weapon in the 4th degree out of Bronx County. That was in 2010. Aggravated unlicensed operation of a motor vehicle in the 3rd degree out of New York County. And that was in 2010. Criminal possession of a weapon in the 4th with intent to use. That was out of Bronx County in, looks like 09. Your Honor, the state is going to be requesting bonds on counts 1, 2, 7, 8, 12, the burglary charges at $15,000 apiece. On the, on counts 6, 11, and 15, I'll be requesting $5,000 apiece. No victim contact, no contact with, one moment, Judge. Gino Tan, and also just noting in the one of the reports from Detective Cusimano from Broward County Sheriff's Office, it mentions that Kurt Kuhn has an alias. So I'd also be asking, should he post his bond, that he be supervised by pretrial release, GPS, and frankly, at this point, I think he poses such a great risk that level 1 is required.
Judge, in speaking of Mr. Kuhn, he's been residing in South Florida now for about 2 years. He's 34 years old. He's has 2 kids. He lives with the mother of his kids in North Lauderdale. They rent an apartment. They don't rent month to month. They have a lease, so they have a contract, and they pay approximately $1,500 a month. Both him and the children's mother basically take care of all the bills and raise their 2 children who's 7 months old and 3 years old. The only person that's going to be helping him pay for his bond or help post his bond is his girlfriend, the mother of his kids. She's a paralegal. He's also working. He's been working for the same company now for about 6 years, making approximately $15 an hour. Judge, from what the state is suggesting as far as his monetary bond, it's something that's going to be out of their realm of possibility. What we'd be asking you to consider is setting a $2,000 bond on each count, which would be on 1, 3, 6, 7, 8, 11, 12, and 15. With the standard bonds that are already affixed to what we're already here for, the total bond is going to be $35,500. Still, if he posts that, he's not going to be released. He's then going to be picked up from Dade County, in which he has a no bond hold. So, Judge, that would be the defense's position.
I appreciate that. All right, according to having read all the probable cause affidavits in this case, and cases, really, I'm going to set bond on counts 1, 3, 7, 8, and 12, which are the burglary cases, but the burglary counts at $10,000 per. I am going to set bond on counts 6, 11, and 15 at $10,000 apiece. The other bonds will remain in place. So Count 1 is $10,000, count 2 is $1,000, count 3 is $10,000, count 4 is $1,000, count 5 is $5,000, counts 6 through 8 are $10,000, count 9 is $1,000, count 10 is $5,000, counts 11 and 12 are $10,000, count 13 is $1,000, count 14 is $5,000, count 15 is $10,000, count 16 on the traffic capias is $500, and the out-of-county hold will be a no bond hold. Good luck to you, sir.
Your Honor, we asked for no victim contact. Mr. Kuhn?
There will be no victim contact.
Thank you.
And no contact.
And as far as my request with no contact with Gino Tan,
Yes, there will be no contact with that. He was the co-defendant, if I.
he's listed as the co-defendant in at least one of the cases. I don't know if it's, I don't want to make an assumption.
Right.
That was no pre-trial conference, just a bond?
Just a bond.
Thank you.
Billy Toby.
He's approaching, Judge.
Mr. Toby, you are charged with 12 counts. The first of which is the burglary of an unoccupied dwelling. The next 11 are, looks like pickup orders or court orders on juvenile cases. I do find probable cause to all of them.
It's more fraud. Call Sharon Lights and ask her.
Set bond on count 1. Counts 2 through 12 will be no bond hold pursuant to the warrants. Good luck to you, sir.
Just ask for,
You set the bond on count 1?
Pardon?
How much did you set?
$2,500.
just ask for no victim contact, Judge.
No victim contact.
Thank you.
Judge, and there's no way to try and see if we can arrange a court date for him as far as his court orders in front of Judge Gillespie at this time?
There's,
Yeah, your office is going to notify the appropriate people.
Okay, okay.
I'll send an email to Corey.
Okay, fine. Thank you. Thank you, Mr. Barbera.
Alshinard Griffin.
North Broward.
Morning, sir. You're charged with 3 counts. Possession of a weapon by a convicted felon. And 2 counts of violation of probation. I do find probable cause as to all of them. It looks like the state. It looks like the possession of a weapon was made when he shot himself accidentally.
yeah, no, I understand.
Any bond recommendation?
Your Honor, Mexico. Whatever, with the probation holds, I'll leave it to the court's discretion.
Okay, I will set bond on count 1 at $5,000. Counts 2 and 3 you're being held no bond. You have a status conference set for the 21st of this month, which is Tuesday at 8:30 in front of the division judge. Let's see who the division judge is, but the person who put you on probation. Good luck to you, sir. Firearms are dangerous. Michael Jones.
Only to himself.
He's approaching, Judge. You see here at Maine, Mr. Jones.
Okay, no problem. Mr. Jones, you're charged with 1 count of petty theft. I do find probable cause. Your bond is set at $750. Good luck to you, sir.
$750 is your bond, sir.
$750. $7,000?
No, $750.
$750?
Correct. Good luck, sir.
Foster?
He's here present, Judge Armaine.
Mr. Foster, you're charged with 4 counts: carrying concealed firearm, possession of a weapon by a convicted felon, possession of or ammo by a convicted felon, possession of cannabis 20 grams or less. I do find probable cause. This is the H and K. Looks like you got charged with the weapon and 1 round.
Yeah, the ammo on one count.
What's Mr. Foster's record?
Okay. 2003, possession of cannabis with intent to sell. He was convicted. He earned a day state prison. 01, cocaine, cannabis, VOP.
Judge, in speaking to Mr. Foster, he's been residing in South Florida his whole life. He's 38 years old. He works for a company called Fast Pro. He does like pressure cleaning. He's been working for them for 2 years, making approximately $22 an hour. That's when he could get work. This company is based on like their clients and stuff like that, so it's usually part-time and he doesn't get that many job opportunities. He lives in Fort Lauderdale with his wife. They've been residing in the same premises now for about 5 years. Judge, his wife is a preschool bus driver. He does not, and they have 1 daughter. She's 1 year old. Judge, financially, from what he's advising me, he believes his wife can come up, if Your Honor were inclined, to set a bond on count 2 of $1,000 and on count 3 $1,000 using a bondman. He believes his wife can afford that amount.
Okay. Well, on count 1, it is $1,000. Count 2, I'm setting a bond of $5,000. Count 3 is kind of a duplication of count 2 in that they're charging him with at least 1 round that was in the chamber. So I'm not going to charge, I'm going to leave that at a 0 bond. And count 4 is a $100 bond, so it's going to be $6,100 bond total. Yeah, I'm gonna ROR, no, count 3. Count 3, I'll ROR.
Yes, Judge. Thank you.
Okay. Cody Seguis.
Mr. Seguis, come on up, please.
I think she's here to see you.
Mr. Seguis, you're charged with 2 counts, petty theft and use of an anti-shoplifting device, or cutting off the shoplifting device, if I remember this correctly. I do find probable cause for both of those state priors.
1 moment, Judge.
Must be you. Oh, okay. There you go. Thank you.
Had some misdemeanors in his past out of Palm Beach, but it looks like the last one was 2012. No thefts.
Judge, in speaking to Mr. Seguis, he's 25 years old. He works for a company, a carpet and tile company. He lives with his parents. Judge, from what he advised me, he contacted his parents, but unfortunately his parents can't afford to post his bond. His father is disabled. He's asking if pretrial can verify his address. He's asking if you would consider pretrial.
At the time of the pretrial interview, just so the court is aware, he did decline.
He declined pretrial.
Yes.
He declined pretrial.
At the time of the interview, the defendant did decline pretrial.
He may decline. I know when I spoke to him, he asked me to ask Your Honor if you would consider pretrial.
I will, pending pretrial verification. Yeah.
Okay. Can he state his address for the record, please? Can the defendant state
Yeah,
his
can you
address
state
for
your
the
address,
record?
sir, for the record?
19371 Dakota Court, Boca Raton, Florida.
The zip code?
19371 Dakota Court, Boca Raton, Florida. 3334.
And who's a contact person who can verify his address? Name and number, please.
My father.
Okay.
His father.
State your father's name and his phone number.
Alfonso.
Alfonso?
Yeah.
Same last name?
Yes. 954-540-8062.
That was 954-540-8062.
Yeah.
Thank you, Your Honor.
Thank you. Philip Balsamo.
Mr. Balsamo, come on up.
Mr. Balsamo, you're charged with one count of violation of probation on a felony charge. I do find probable cause. You're being held no bond. You have a status conference set on 11/21, which is Tuesday at 8:30 in the morning in front of Judge Siegel. Good luck to you, sir. Roger Mars.
Judge, Mr. Mars, I was informed by North Broward that he needs a sign language interpreter. We tried to get one earlier this morning. They indicated that there will be one in the building at 1:30 this afternoon, so if we could just roll it over.
Yeah.
Well, and the only reason I'm only suggesting this because it's a VOP. Can you read it? Because normally what we've done sometimes in the past, rather than having the cost of a sign language interpreter, if you can communicate, the deputy could read that.
I'd prefer to have
Okay.
a sign language interpreter, quite honestly.
Okay.
They will be here, so it's
Okay,
fine.
so I'll
They're-
roll this to 1:30.
Perfect. Thank you, Judge.
Anthony Lemon.
Mr. Lemon's approaching, Judge.
Mr. Lemon, you're charged with one count of violating your probation on a felony charge. I do find probable cause you're being held no bond. You do have a status conference set for December 1st of this year at 8:45 in front of Judge Fine, Marty Fine. Good luck to you.
Good luck, sir.
Christopher Branham.
Mr. Brandon, come on up.
Mr. Branham, you're charged with one count of violating your probation on a felony charge. I do find probable cause you're to be held no bond until your status conference on Tuesday in front of Judge Merrigan at 8:45. Good luck to you, sir.
Good luck, sir.
Daniel Santiago Hernandez.
Mr. Santiago, come on up.
Sir, you're charged with 3 counts of violating probation on felony charges. I do find probable cause. You're being held no bond. What, on count 1, what is the bond on that?
For some reason, it was ROR'd. I don't.
Okay, you were ROR'd on count 1. Counts 2 and 3, you'll be held no bond. You have a status conference on November 28th at 8:30 in front of Judge Colra. Good luck to you, sir. Yes.
Can we recall Mr. Sagis?
Yes.
Judge, Mr. Sarkis is not present.
Okay. Can we get him back? What's the issue?
Judge,
Yeah. Yep. Edgar, is it possible to get Mr. Sagis back?
I know the deputies are working on it, Judge.
Okay, great, thanks. All right. Just, I think pretrial had some issue and, okay. Fresson, Fanor?
Okay.
Mr. Fanner is approaching, Judge. He declined the services of public defender.
Mr. Fanor, you were charged with battery on a officer, firefighter, EMT, et cetera, and resisting an officer without violence.
Really? Why does it? I want to see what's going on with the case.
You find probable cause.
Did he?
Bond is set on count 1 at $1,000. Count 2 will be $1,000. Total $2,000. Good luck to you, sir.
Stolen vehicle.
Chester McCollum. Okay. Posted.
Mr. McMullen, I believe, bonded, Judge.
Okay, I do find probable cause.
All right, get on the ball, Gloria.
Siobhan Boyd.
You sure?
I've been advised he bonded, Judge.
Okay. Cliff Carpinella.
Out there somewhere.
He's coming, Judge. He's approaching. Come on up, Mr. Carpinello.
All right, Mr. Carpinella, you're charged with 5 counts. The first is sex battery on a victim 12 years or older under special conditions, and then you have violations of community control for counts 2 through 5. I do find probable cause as to all the counts. State?
Yes, Your Honor. Just based on the allegations in the probable cause affidavit and noting the various charges he's on probation for, including but not limited to attempted strong-arm robbery, state will be requesting a $25,000 bond in order of no victim contact.
Judge, when's the alleged date of incident on count 1?
Count 1, 11/14. Looks like, hold on, let me just make sure.
Yeah, that's what it says.
11/14. So it would have been Saturday.
25.
Okay. All right, court's gonna set bond in the amount of $25,000 on count 1. Counts 2 through 5 he will be held no bond.
Can I see the docket real quick, just so I know what resets are coming up?
Shamar Van Riel.
Mr. Van Riel is here approaching, Judge.
Good evening, sir.
How you doing, sir? Mr. Van Riel, you were charged with 1 count of grand theft, auto. I do find probable cause. It's an ad charge. Bond is set in the amount of $1,000 on that. Good luck to you, sir.
Judge, Mr. Van Riel has advised me he can't afford it. I believe he's in custody on other offenses in which he's still here. He can't afford to post his bond. He's asking, Your Honor, if you would consider releasing him, Judge. That's what he advised me to ask you.
So,
No, not this time. It's an ad charge, and he can resolve it with the others if he wants to. Lawrence Perry.
Judge, Mr. Perry is approaching. He declined to serve as a public defender. He has private counsel, Mr. David Seltzer.
Okay. Mr. Perry, it looks like you've got a couple of ad charges here. Transmitting information harmful to minors on counts 4 and 5. I do find probable causes to both of those. Your bond is set at $1,000 for each one of those.
Your Honor, Mr. Perry was placed on pretrial for counts 1 through 3.
these were supposed to be attached to those. You heard them earlier this week.
Okay, he has a bond.
Plus
on
pretrial.
counts 1 through 3 plus pretrial.
Yes.
With GPS, yeah.
I will do the same with
For
his.
this, okay, thank you, sir.
Fitzroy Morton.
Mr. Morton's here present, Judge O'Malley.
Good morning, Mr. Morton. You were charged with 2 counts, trespassing of an unoccupied structure or conveyance and a violation of probation or community control on a felony. I do find probable causes to both of those. It's a 0 bond on count 1, the trespass, and it is a no bond hold on the felony. You will have a status conference set for Tuesday at 8:30 in front of the division judge.
Because this is the last guy on the docket.
You do have a status conference on violation of probation.
I think, is FK Judge Siegel?
may be Judge Siegel, but whoever placed you on probation, you have a status conference in front of that judge.
That's the easiest way to put it.
For Mr. Perry, his transmit info harmful to minors. The bond was set at 5,000. You're gonna leave it at the 1,000 for charges counts 4 and 5?
Yes.
Okay, thank you.
No, I was just saying I'm fine with that also.
Mr. Devine, you were charged with 6 counts.
He's still sitting.
We have Mr. Morton.
Oh.
If I'm not being held on it. Okay, Judge, hold on 1 second, please. I was trying to explain to Mr. Morton something.
Okay, go ahead.
Just curious. We don't have any. We didn't have any.
Mr. Morton, I finished explaining to him what happened. On the trespass, because he has basically a 0 bond, he's not really getting credit on it, but he's being held no bond. Would you consider putting a $10 bond on count 1?
Yeah, I'll put a $25 bond on count 1. I was thinking that myself. I apologize to anybody. It makes good sense.
Thank you, Judge. All right, thank you. Appreciate it.
Thank you. All right, Leroy Devine.
Mr. Devine is here present, Judge?
And Judge, count 1 is a it's a purge on a civil writ. If he wants to resolve 2 through 6, the state's offer to be time served.
Yeah, they're gonna do it, just what we talked about, okay? So let the judge know you want to accept the state's offer. Okay?
None of these are DWLSs from what I can tell, so there wouldn't be any.
Operating without.
Yeah, exactly. There wouldn't be any other
Okay.
effects to his license.
All right, sir, you're charged with 2 counts. Count 1 is writ of arrest on a 2010 case, it looks like, and the bond on that is $239. But counts 2 through 6 are warrants on traffic criminal offenses. And the state indicated to me that if you want to resolve those, then they would offer you an adjudication credit for time you've already served on those counts. But that would still mean that you'd have to post a $239 cash bond.
Yes, I want to resolve that.
Okay, 1 second. Okay, so apparently your bond has been posted on count 1. So, sir, raise your right hand, please. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Can you state your full name, please?
Leroy Devine.
All right, Mr. Devine, you can put your hand down. Mr. Devine, I indicated to you that the state is offering you an adjudication credit for time served on counts 2, 3, 4, 5, and 6. Is that something you want to do?
Yes.
How do you wish to plead, guilty or no contest?
No contest.
All right, I'll accept your no contest plea on counts 2 through 6. I will adjudicate you guilty, give you credit for time you've already served on those cases, and I'll waive court costs. Good luck to you, sir.
All right, thank you.
Judge, I believe pretrial.
Oh, yeah. We have Mr. Seguis. Mr. Seguis?
We can't. No, you definitely
Your
hear me.
Honor, I'm right here.
Oh, I'm sorry.
Oh,
Your
yeah.
Honor, he was pending verification of pretrial.
Yes.
I did speak with his father, Alfonso Seguis, who indicated that the defendant does reside at that address and can return there. However, he is concerned that he does have some drug issues. And so what we're going to ask is that the court will order him to do a drug evaluation and random urinalyses. I didn't want to just verify him and have that on an order without the PD and the defense and the defendant being made aware of what the father told me.
Okay. Well, Mr. Seguis, if you want pretrial, that's going to be a condition of pretrial. Do you want to do pretrial with those conditions?
Yeah.
Okay, so there'll be a drug evaluation and random urinalysis, correct?
And he is no longer pending verification, Your Honor. He has been verified.
Okay. you have anything else, Hector?
Judge, as far as I know, the regular docket is finished, but I didn't get any sort of third look docket, so I'm right now at a loss if there is
We don't
or
have any.
not.
We don't have any apparently.
Do you know if there's gonna be one for this afternoon? Nobody's really telling me anything.
They're saying no. They're saying no.
Okay,
All right?
okay. Oh, Judge, one more request. Judge, what time are we starting this afternoon? Because I know normally on Fridays, we start at 1 o'clock. So they bring the gentlemen, the people in at 12:30, so I wanted to know what time are we gonna start?
Yeah, I see no reason not to start at 1 o'clock like you always do, unless you have some issue that you need to do
Oh,
it
no,
later.
I don't. It's Judge Cantor, you're in control. You can say what happens.
No, I won't mess anybody's schedule up. We'll do it at 1.
Okay.
All right, thank you.